Yeah.
Are you working out? Are you going to the gym?
Yeah.
Yeah, good.
Oh,
yeah, you look good. Yeah.
Getting shredded.
Yeah? Are you?
It's go time.
Yeah, okay, all right. I like it.
Your motivation to me, Abe. I see you.
Oh, me? Oh,
You're
no.
looking good, man.
No, I need to work on my the midsection.
You're having fun. You're having fun. I see you.
I do love going to the gym, though. I got a fun gym I go to. Cool. So I have attorney Carlos Arce here. Wait, which camera am I looking at, bro? Oh. All right, my bad. I have attorney Carlos Arce here. He is working in healthcare law. He's working towards becoming board certified in healthcare law. He is a genius. He was on our podcast before. He answered all sorts of crazy laws that I had no idea even existed. I said this right spinal case came out. I could think of no one better to have on this podcast to talk about the changes. What are the options? How can we do things legally? The biggest thing today is one, this is just general advice that we're giving. Carlos is not your attorney. You can't be like, hey, I watched that podcast and I got all my legal advice. If you guys have a situation, a legal issue, call his office, set up a meeting, talk to him. If you have specific things, okay? Because everybody's office is not just a chiropractor office with LMTs. Some people have medical doctor offices, APRN offices. There's a variety of different things. So what we're talking about today may or may not apply to you. We're going to give general overview, okay? And we're going to give you we have some citations here on the website that this is going to be posted on as well. There's going to be references, materials, copies of court orders, and things like that. So we want you guys to get the information. He's super knowledgeable, and I have him on here because he's a genius when it comes to healthcare law. So I wanted him to talk to you guys about this from his perspective as a healthcare lawyer. Obviously, I do a lot of PIP suits, so that's one perspective. I also talked to, in getting some of the information on CPT codes, Dr. Marty Kotler from Target Coding. He's an expert on CPT codes, right? So we're trying to get brilliant minds together here. I'm not one of them, but we're trying to get the brilliant minds together. I'm good at bringing people together and figure this out so that everybody can say, hey, this is the steps that I'm going to use moving forward. So Carlos, welcome.
Hey, thanks for having me again, man.
Thanks, man. Appreciate you. So we have the case here. I'm just going to, we're just going to talk about it verbally. Geico sued a clinic in Tampa called Right Spinal. And their biggest allegation in there was like, hey, you have LMTs performing physical therapy, and the judge in that case issued a ruling on July 6th, and basically, I can read you some of the excerpts, but basically it says here, man, this is really small font. It says, does the Florida no-fault law prohibit reimbursement for PT services that LMTs perform? If it does, Geico is not required to pay $700,000. Because it's undisputed that LMTs provided all of the physical therapy services. And when we're talking about physical therapy services, some of those codes are that I saw in the particular case, I should find those, was neuromuscular reeducation was one of them, and also therapeutic exercises was also one of the codes that they were billing at that clinic. And I'll double check all those and put them in this link on the website. And so the court said, the statute prohibits billing from an LMT's services. Thus, Geico is entitled to summary judgment, meaning they win, and as it relates to PT services. So the clinic was ordered to pay about $700,000, and they go on again to say a doctor's supervision is not an exception, because I've had people say, well, the LMT really works under me. I'm the chiro, and the LMT works for me, and so they're under my supervision, and the judge said, nope, that doesn't count. He said the plain text of the PIP statute, which came out in 2013, 10 years ago, specifically excludes reimbursement for any work done by an LMT. So the question is, where do we go from here? The case was appealed to the 11th Circuit. 11th Circuit said, we agree wholeheartedly. So where do we go from here? So that's why we got you here to tell us.
Absolutely. Thanks for that, Abe. This case is very interesting because the court went back and forth about the status of an LMT doing services as a certified or registered chiropractic assistant. Mm-hmm. And there's also the argument of a physical therapy assistant. Mm-hmm. And they try to elude that, and they try to say, that these LMTs were essentially working in that scope and that they were working under the scope of the supervision of the physician.
Okay.
Which in the case, they kind of start to convolute the difference between a medical director and a supervising physician.
Okay.
I found that interesting. I'm going to talk about that in a second because I think I always try to give some insight on that because verbiage is important and words of art are important.
Mm-hmm.
But to the point about the LMTs, you know, the basically with this fourth DCA decision, it's pretty clear now, and everybody hearing this, you should know, massage therapists, don't put them in they can't bill PIP.
Mm-hmm.
This is just very clear. You know, I would have thought back before this came out, you know, possibly, because the way that the statute's written of what medical services and medical benefits that could be reimbursable,
Mm-hmm.
it was all about, you know, as long as there was a supervision of an MD, a DO, you know,
Mm-hmm.
an APRN, a chiropractor,
Mm-hmm.
there could be reimbursement. This kind of sets that groundwork and actually sets the clearance for it. Now, the problem with that is if you have been doing that, you're going to have a problem because these landmark decisions, what they do is now the carriers grab these and they use these as exploitation tools.
Yeah.
And they'll go after you. This is when the SIU audits start to initiate,
Mm-hmm.
and they have these big law firms, you know, that will take these cases, and this is what they're going to stand on. And this is the tallest, you know, ruling in the land.
Yeah.
As it relates, I know we have talked about, you know, where does the statutory guidance go? Is it, you know, this the Florida Board of Chiropractic?
Mm-hmm.
Does that decision stand?
So here's the question that I had, and I think the biggest thing is, I know the answer, but I want to hear you say it.
Mm-hmm.
Can an insurance company like State Farm or Geico go to all the different clinics that have notes that say, yeah, this was performed by LMT Susie? Can they go back and say, hey, this case came out, you owe us money? Can they do that?
Absolutely.
Okay.
Yeah.
And what's the time frame roughly that they can go back?
Well,
how many years?
Well, you know, there's an insurance statute that governs essentially when insurance companies can dispute claims. I believe it's 4 years that they can go back.
Yeah.
And 4 years, I think, if there's out of network, 5 years, it might be if you're in network, but this is out of network because it's PIP. So I'm assuming they can go back 4 years, and I'm assuming they will.
Yeah.
And the way they'll do it is they'll probably populate it by the highest reimbursable clinic or establishment that they paid, and then they'll true it up from there. The federal government does the same thing as it relates to Medicare or Medicaid fraud. They kind of put, you know, their top targets, and then they always go after the big money, and they downscale from there.
So you're saying they're going to basically look at their 1099s of what they paid clinics, gather them up, and be like, this guy got paid a fortune. Let's hit that guy first.
Yeah, the carriers got algorithms that they run, and what they'll do is they'll populate it by CPT code. So what they'll do is they'll put it into, like, let's say high reimbursing clinics, and they'll figure out, well, how much of this was PT related code or how much of this was a therapy code that could have been done by an LMT. And what they'll do is they'll factor that, and then that's how they'll pick their targets.
Yeah. So if you're watching this and you're a chiropractor and you had LMTs and they touched your patients, there's a potential risk there. There's a potential exposure. Yeah. Doesn't mean, you know, you stay up for the next month crying about it.
Right.
But what it does mean is if you were making a lot of money from some of these carriers, billing a lot of PIP, that you could potentially be a target. And I already know, I talked with some of the attorneys that, you know, they sue doctors for alleged fraud, perceived fraud. And they told me, yeah, we're already having meetings with doctors who used LMTs to perform these services. They were already going after the clinic for something else, and now they're throwing it on there. It's like, hey, we got slam dunk right here, you know?
Yeah, and they always bolster their claim. You know, the claims come out as it relates to fraudulent billing, and then they'll always tack on the typical civil RICO, which I know, Abe, you do, defense for, you know, providers in that position, and they do the fiducia because they're claiming that these are just unethical practices. So when you see that lawsuit come your way, or SIU, you know, you're not trying to play nice. Maybe you didn't get a lawyer because they said it's a friendly interview. Well, it's never friendly. So make sure you go in with counsel. Do not appear on that alone.
Yeah.
Don't, like I like this, I'm going to be very plain about it. Don't cheap out there. Don't cheap out at the interview because that's going to set the groundwork for the catalyst that's coming after it.
Yeah. I think if you don't get an attorney and an insurance company says, hey, we want to talk to you, you need to get an attorney. That's the first thing you do.
Right.
Yeah. So I guess where do we go from here, right? And what do we do? So I actually, on this website that we're going to post a video on, we broke up the different types of CPT codes because, you know, the issue is the PIP statute says that the PIP statute says that the CPT code book applies. Okay, so I pulled up the CPT code book, and I have here codes that do not require direct one-on-one patient contact. And I have here hot packs, traction, mechanical, e-stim unattended, vasopneumatic devices, paraffin bath, whirlpool. And it says in the handbook that these can be done by an unskilled, unlicensed person. There's another section of codes, which is actually attended e-stim. I can't say that word. Iontophoresis. That's when we start using codes. 97033. Contrast bath, ultrasound, Hubbard tank, unlisted modality, which is the 97039. And that one says requires direct one-on-one patient contact, but does not specify with a licensed person. So that's kind of a gray area. My advice is get a licensed person to do that, to do those codes. It says direct one-on-one. It doesn't say with whom. And then there's a third section here that specifically says direct one-on-one patient contact by a qualified healthcare professional, which is defined as a licensed person. PIP does not allow LMTs, so a licensed LMT doesn't count. A licensed
and
MT.
Acupuncturist. I saw in the case law they referenced it. Too.
Yeah, because it was in a statute in 2013, and there hasn't been an acupuncturist in PIP in so long.
But I remember when they were, and that was an issue.
They were, yeah. I can only imagine back in the day, like there was a clinic somewhere that was like, hey, you were in an accident, we're gonna do acupuncture on you, and that's it. And then they have a doctor come by, they do a cursory exam, and then you're just stuck there. That's why, for everybody watching this, that's why there was clinics that I knew about that it was owned by an LMT. They had a doctor come by once a week. The doctor would write a script for new patients and say, hey, you need 4 weeks of massage therapy. I'll see you again in 4 weeks. We see how you do. And so they'd come by once. They come by for a follow-up. They do 4 weeks, just massage, no MRIs, no x-rays. The doctor was getting paid per patient. And if they said, hey, look, this guy's got a really swollen knee, it's bad, he needs to get an MRI, the clinic owner, the LMT, would say, no way, not happening. That's, $900 from the PIP. We're going to do massage on the knee. They'll be fine. And after the 4 weeks and then the other 4 weeks, they just dump them because the PIP is gone. And so that's why they passed this law, is to exclude clinics like that. I don't think that the legislature intended to exclude, hey, if an LMT is working under the direct supervision of a chiropractor, but that's what the court said. And so,
I'll tell you where there's a little conflict there.
Okay.
So like I talked about earlier, there's certified chiropractic assistants, right?
Okay.
So the CCPAs.
Okay.
And then there's registered chiropractic
RCAs,
assistants, right. The difference is certified, they go through a course. They go through a training, they go through a schooling. It's like a 2-year program, and then they get a certification, and then now they can essentially supervise even the registered chiropractic assistants.
Yeah.
The registered chiropractic assistants, as long as a chiropractor deems you eligible and ready and you've been trained, you can use them.
Yeah.
And they can work under a chiropractor. You can even work under the CCPA.
Yeah.
What this case, basically what the defense here was alleging was, well, the LMTs were working in that capacity. But the court still said no, which is troubling. Because, so at what point is it okay? Just because they had a certification as an LMT, they couldn't be educated and trained by a chiropractor under that supervision?
Right.
Because the chiropractic statute would say yes. So there's a conflict of law there. That's what I found troubling, because I've had that question asked for me, and I've given the advice, and I've said, because people have asked me, can I hire a registered chiropractic assistant to do services under me? And I've said, yes, as long as you meet these requirements and they register with the board of chiropractic, which is the requirement.
Right.
And to see this now and this position, it's more than ever a time to double down on the experts, because look at how this can now cause you an issue when you just followed the law.
Right.
But you don't know that this case is lingering, then you're at risk.
Right.
Problem.
Yeah.
I see a problem here.
Yeah, for sure. And so to go back to that about the CCPA that you mentioned, I think that's where all of these chiropractic clinics need to go, is they need to get their people registered for the CCPA. The only problem is there's only one course in the whole state that's approved. to provide the course.
Right.
And it's a 13-month course. It's 200 hours, and they stretched it out over one weekend a month for 13 months. Well, that's not going to help anybody right now. And the people who run that program, I've been in talks with them, and they're like, look, we're trying to get an accelerated course from the board, but likely won't get approved until February. So I'm thinking, man, if you want to get in compliance, you can't right now. So it's a really tough time. More interesting, you brought up the board rulings. So the Board of Chiropractic issued 2 rulings. I'll read you one of them, and it says here, stating that a person who's not licensed, whom the chiropractor knows to be trained and competent, perform under myofascial release, either mechanically or manually. And so the board said that if a chiro knows somebody to be trained and competent, even if they're unlicensed, they can perform myofascial release. Right. However, I want to specify that the PIP statute says you have to practice according to the CPT code book, which requires manual therapy, is right here, 97140, requires, it's under that section where must be a qualified healthcare professional, i.e. a licensed person. And so even though the board says, that's okay for health or for cash, but not for PIP. So I want to be clear on that. Do you know where the board ruling is at? Like, how does that work with, if there's a conflict of law, does the board ruling, would a court say something like what I said, or you think a court would, and how does that work? Do you have any idea on that?
I think that it's a defense. I think that if you're the defendant in this case, you're using that as basically administrative guidance. Okay. As you can remember from law school a long time ago when we were there, it usually works as primary citations and then secondary sources. Okay. And I would think that a board decision is a secondary source. I would think that a legal case and a statute, maybe a cleared law that has no conflict, is probably the primary citation in this type of situation. So that's the primary defense. Okay. The secondary defense would say, well, we relied on the board decision because that's our administrative governing board, and we were acting as licensed professionals under those guises. Okay. I would say that then a court would just have to analyze that, and it would depend on, is it a public policy argument to say, oh, we have to hold someone to the scrutiny of a case versus what they've, by their board licensing, is telling them what to do. Yeah. I would think that it would just depend. How many people are doing it? Yeah. How many cases are active?
Yeah, because this is the way business has been done since I've been doing it, and I just reached like the 15-year mark. And when I was doing it, I was working as a law student before that, and that's how they did it. They had LMTs doing everything. Yep. So what's infuriating about this is the court, the Middle District, the 11th Circuit, even the DCA opinion that you mentioned, they don't bring up the Board of Chiropractic orders anywhere in there. They don't say like, we looked at this. So it makes me wonder, was it brought up by anybody?
I think that they were exclusively holding true to Florida law, which is the statute. Okay. And they probably were interpreting the PIP statute because that's what they honed on a lot, was what were the medical benefits that are recoverable. And then the standard of licensure was all about that statutory guidance. Yeah. But like we've talked about before, there's the PIP statute has so many conflicts with so many other statutes in Florida. So it's kind of like, which one are we going on this time? Yeah. And so, so we talked about the board. There's another board ruling that says a chiropractor may lawfully delegate the performance of PT modalities. Doesn't specify which code specifically, but just says PT modalities to unlicensed assistants whom the chiropractor knows to be trained and competent. That's an older court order, again, not mentioned anywhere in this case, but I don't know. And so again, the issue here is get a CCPA to do the work in your office. Do the work in your office. You can have an unlicensed person perform some of these codes, but not all of them. And so, and that's all delineated here. We just spoke about that. So another like surprise question that I got and I wanted to ask your opinion about it is RNs. So there's some clinics that are set up, they're ACA licensed clinics. They have a medical director,
and then there is an APRN supervising everything in the office day to day. And the question is, can an RN treat a patient for some of these CPT codes that require a license? Can an RN treat those patients, and if so, how do we do it legally?
Right. All right. Well, let's start with medical director before we go anywhere else, because I think everybody needs to understand there's a difference between a medical director and a supervising physician or collaborating physician. Okay. Those all mean different things.
Okay.
So a medical director is, in Florida, it's when you are a healthcare clinic, meaning you're licensed under statute chapter 400. Okay. A medical director is somebody that is in the practice to monitor the coding practices of the practice, not to supervise the physicians. And nowhere does it say that that person is the supervisor of the persons that are in the practice. Okay. However, the statute, the Healthcare Clinic Act, says that the medical director must supervise up to the scope of practice of what is going to be done in the healthcare clinic. Okay. What does that mean? A medical director could be a PT. A medical director could be a chiro. A medical director could be an MD or a DO. If your practice is only doing PT and anything under that PT could supervise, then the medical director could be a PT. Okay. Not supervisor of the persons, but supervisor of the coding practices. If the practice is
with ACA.
With ACA. Okay. If the medical director is an MD or DO, which is usually what I recommend, because they're the gamut of things that could be done under somebody licensed under the MD DO statute, essentially allows your healthcare clinic to have availability to do way more items. So you have to be mindful of when you're getting a healthcare clinic of what you're selecting that you're going to do in the practice. Okay. Because let's say you didn't check off PT and you just did general medicine, and now you get a PT in the practice and you start billing PT codes, you're in violation of the Healthcare Clinic Act as well. Okay. You're now at risk with ACA, and I'm going to tell you, the carriers, PIP carriers, are going to figure that out. They're going to use that against you, and they're going to say they weren't even licensed appropriately to do these services. So, again, like I said before, you're going to do a healthcare clinic, consult an attorney. I mean, there's good consultants out there that can help, but they won't know these nuances of the legal risks like we see them, because we defend these type of lawsuits. Okay. When ACA comes after clients for this type of licensure concern, I handle that. Okay. And that's why I know this little nuance about that. Let's go into supervising physician, to your question. Okay. So you said, what can an RN do, and can they do these types of therapeutical type codes? Well, a registered nurse is not allowed to act autonomously. They cannot act in their own individual capacity. They cannot diagnose and treat independently. They must do so under something called a standing order. Okay. Similar to a hospital, standing order means it's a script of things that the RN is allowed to do at the consent and supervision of the physician, whether that be general or direct supervision. Okay. There's differences there. Okay. Direct supervision means in suite, means in the office, or essentially on top of the RN while they're doing the service. Like, they're looking at them while they're doing it.
Are they in the building or in the specific room with the patient?
Direct supervision can mean many of those things. It just depends on what the CPT code says. So it may say has to be in the room or in the suite or in the building. Okay. So gotcha. Direct could vary. Okay. But Florida typically stands as direct being in suite. It's like
in the room.
In the suite, meaning in the
office space, the whole space.
Right.
Okay. Not
but it
the
just
individual
depends
room.
on the CPT code, and that's going to vary. I would say I don't want to talk about CPT codes because I'm not a billing expert. Okay. Marty's somebody that I would tell you to call because he understands that stuff. Okay. And gotcha. He'll sign you right where you what CPT code with what supervisional requirement. Okay. Because you're going to have to indicate that when you submit reimbursement, either through your HCFA 1500 or if you're submitting the claim, through commercial insurance or whatever, you have to submit who was the supervisor. Okay. So RNs, let's go back to that. The RN, can they do the physical therapy type codes? Well, if the physician that is supervising them through a standing order is allowed to do that code and is allowed to delegate that code to them, can they do it? Well, the answer is yes. PT codes are done by multiple various of providers. It's just not physical therapists. Okay. Chiros do PT codes. APRNs do PT codes. RNs, I don't see why they couldn't, because if they're doing it under a standing order and an MD and a DO can do it, they can. I represent ortho practices. The doctors themselves do physical therapy codes. Okay. Because there's things that are inherently considered physical therapy in nature, but not really a physical therapist has to do it themselves.
Okay, gotcha.
So to answer the question, RN can do it. However, they must comply with the supervisional requirement.
Okay, gotcha. And so another question that I was asked is, which I kind of didn't prep you for, but a PTA.
Mm-hmm.
Can I hire, Abe, I'm a chiropractor. Can I hire a PTA to work under me? Does a PTA have to work directly underneath a PT? I guess is the question.
Well, the statute would say that a PTA has to work under licensed physical therapist.
Under a PT, okay.
Okay. Now, could there be a physical therapist and a PTA in the office and a chiropractor's there and the chiropractor's delegating things to the PT and the PT's delegating it to the PTA? In theory.
Okay.
Yeah.
Okay.
But you're getting into that gray area now where you're looking at it like, well, the statute says that they're supervised by physical therapists.
Mm-hmm.
Physical therapists, and they're going to do a treatment plan, when it's a plan that extends 30 days, they have to get it, validated by MDDO, APRN, or Chiro.
Oh,
so
okay.
Chiro's in the mix there.
Okay, so a Chiro can write the script for PT.
They could write the script for PT, and they could also validate a treatment plan that exceeds the 30-day plan.
Okay, so PTs are expensive.
Yeah.
PTAs more expensive than a CCPA.
Yes.
So I'm thinking in my head CCPA is the way to go for people because I don't even think you can find a PT right now because they're in overwhelming need, like a PT, right? Does a PT have to be on site for a PTA to work? Is it that kind of direct supervision, if that's the right legal word? Does a PT have to be on site?
That depends on the type of code and the type of procedure. Because I from my reading of the statute, and I have to look at it. I haven't looked at it in a few months.
I didn't prepare you for this.
Yeah,
sorry.
but the PT from the last time I read it, there has to be a supervisional delegation. I think it's some code. Some services can be delegated.
Okay.
That they don't have to be like on top of them present, but some things they have to be present for it.
Okay. Okay.
Yeah, the same applies for chiropractors. In the CCPA world, there's things that chiros can only do and CCPAs cannot, and the same thing with the registered chiropractor. Yeah.
Yeah. Okay. And so what else do we want to talk about? Do you have any other ideas on how to maybe tackle this problem of, LMTs are out, so that's done. But how does a chiropractor treat PIP patients if, let's say, this is actually, I think how this case came out with Right Spinal is they were seeing Geico was getting the bills for Geico, and they're like, hey, we're getting like 15 patients a day, each day from this one clinic. How in the hell do they have one doctor submitting bills for this 15 patients? And then, by the way, that doctor who was signing the bill is a medical director at 4 other clinics, and he was signing their CMS 1500 forms. And so they were pumping all this through, and they're like, wait, we got 15 from this doctor at this location, 5 from the same doctor down the road, 5 patients from another clinic down the road with the same doctor, and they added it up. They put it in the lawsuit. They're like, this guy's working 40 hours in one day doing direct one-on-one care, and I think that was like the red flag. So if I'm a PIP clinic and I'm doing chiro and therapy codes, they're timed codes, a lot of them, so they're adding them up. They're adding up the minutes. I guess the overall problem is how do I do this without, if I have 10 patients in a day just from Geico, how do I get around doing this, the right way? Because I think, I want to say this, I think 95% of the clinics and doctors out there want to do it legal. There's always that 5% that you're like, oh my gosh, it's like my, the cousin that you don't want over for Thanksgiving, which is around the corner. But 95% of people want to do things the right way, but they also want to do it in an affordable way. So are you seeing any clear path besides a CCPA or maybe this RN, if it's a medical doctor style clinic versus a chiro? And are you seeing any other options?
Let's go back to the case for the medical director thing.
Okay.
So it was a healthcare clinic.
Yeah, it was not doctor owned. It was a healthcare clinic.
It was a healthcare clinic, and it was a medical director. Like I went back. Let me go because this is the problem.
Okay.
The problem is the internet is not your friend on this one.
This is where you need an attorney.
No,
this
one's it's wrong. It's wrong. Everybody tells me, like, in wellness, people say, oh, because they're maybe in a CPOM state, which is a corporate practice of medicine state, where that means that non-licensed professionals cannot own a medical practice.
Like Florida.
Florida, you can.
You can.
If you have a healthcare clinic license,
Okay.
or if you're doing cash, you
Okay.
don't need to be physician-owned.
Okay.
You could be layperson
But
owned.
like New York, you cannot own.
No, that's a very strict corporate practice of medicine state.
Okay.
Medical director
Mm-hmm.
means what the ACA healthcare clinic statute says.
Mm-hmm.
It's somebody that's supervising the billing practices of the practice.
Okay. That's the one where they have like 10 or so duties that are in the statute that say like A,
That's
B,
right.
C, D.
That's
Those are
right.
the second. Okay. That's
That's
it.
right.
Okay. Gotcha.
People use medical director as well. I own a medical practice and I have a medical director.
Mm-hmm.
And they think that guy is like the supervisor for the practice. Well,
Mm-hmm.
I guess in theory, but in states where there's CPOM restrictions, they're saying, well, that I have that guy and now I'm compliant. No, you're not. You're actually non-physician owned and you're violating corporate practice of medicine statutes in those states.
Mm-hmm.
So people throw medical director around loosely, and they try to confuse it with supervising physician, and they try to confuse it with treating physician, and they try to confuse it with the real thing, which is the supervisor for coding.
Okay.
In this case, the medical director was supervising 4 other clinics.
Mm-hmm.
They're allowed to supervise up to 5.
Mm-hmm.
Okay. He wasn't really. I saw the argument, but it's very hard to prove that. Like, how can you say, oh, yeah, he was also the treater? Well, can a medical director of a healthcare clinic also be a treater in a practice? The answer is yes. To your point, how can you be at 2 or 4 or 5 places at the same time?
Mm-hmm.
They're not dumb. They're
Right.
going to look at all the CPT codes. They're going to look at the entries, the HIC 1500 of the day that it was performed, and it's not logically possible. The same argument for this goes for commercial insurance, Medicare, Medicaid, all the same thing.
Okay.
And this is a common issue I see as
Okay.
well. So to answer your question, I think that they need to where they went wrong here was
Where the clinic went wrong?
where the clinic went
Okay.
wrong was that they should have had, if I was their corporate
attorney.
counsel, I would have
Okay.
said, all right, well, not only is he your medical director, and here's the medical director agreement that you must submit to ACA to get licensed. That's a document you need.
Yeah.
I would also say, if the person is a treater, make sure there's an employment agreement or a 1099 agreement that says they're going to do services.
Okay.
I would go further and say, if they're going to supervise individuals,
Mm-hmm.
depending on the licensure scope, whether it be a RN, standing order, whether it be an APRN, collaborating physician agreement,
Okay.
or any other specialty, PT, whatever they're going to look at, or chiro, or whatever they're going to look over,
Mm-hmm.
document it. Document and follow it.
Okay.
Because now you've got a refutable presumption that you'll say, no, this was a medical director, but also was a supervising physician for the practitioners.
Okay.
I think this would have bolstered this case. They would have had a way better result because, therefore, all that stuff I'm just talking about, guess where it's at? It's in Florida statute. They referenced Florida statute throughout the case. So that would have been a great defense. You would have said,
Okay.
but by statute, also the person could supervise and could do this and could do that and could delegate this.
Okay.
That's where I saw a lot of the issues. And that's where I would recommend, if you want to get out of the trouble, is compliance from billing practices. Make sure you have these things printed out, privacy policies. Make sure you have the things that you need to operate legally, and that everybody understands in your office how it flows and how it works. Follow
Okay.
it. Don't just have documents and say that's it, because then the
Yeah.
government will make the argument of sham arrangements. And you've heard me talk about this wording,
Yeah.
sham arrangements, saying you have it there just to prove that you were in compliance, but you're not really in compliance. You just had them as a rubber stamp.
Right. Okay. All right, cool. So another question here is, how do we, as attorneys or as clinics, how do we reduce the risk of a lawsuit from State Farm or Geico as it relates to this LMT issue?
Right. So as it relates to any SIU audit or any investigation from a PIP carrier, the risk is always going to be present, no matter how compliant you are or how not compliant you are. The only thing you could do is prepare by leading a life of corporate compliance and medical compliance in your practice. I say this often, and it's essentially the catalyst to revenue in healthcare is compliance.
Okay.
Because if you don't have privacy policies, if you don't have billing policies, coding policies, procedure policies as it relates to medical procedures, who can do what, how can they do it, onboarding process of patients, who do they go to see first, then who do they go to after? If you don't have these things written out and you don't follow that kind of diagram, you're going to run into a problem that when you get audited and you have to explain yourself,
Mm-hmm.
it's all verbal. You're all flustered. You don't know what the right thing is to say, and you're not going to know unless you have a lawyer. And the truth is, the lawyer that's in the room with you can't even speak for you, because I've been in these interviews.
Okay.
I can't talk. All I can say is we're going to take a break, and that's it.
Okay.
And that's all I can say. And I'm there to help with that part of it, is to understand what they're asking so I can then help my client, prepare a defense.
Yeah.
But it's too late at that point.
Mm-hmm.
That's the wrong call. The right call is, hey, I'm in practice right now. What would you suggest I do if I bill PIP or I bill BI?
Mm-hmm.
Because as you've seen with the new legislation and tort reform,
Mm-hmm.
they're getting aggressive.
Yeah.
And it's not just on PIP. It's BI too.
Oh, yeah.
So
Yeah.
I would say corporate, practices of compliance in your group
Mm-hmm.
are going to lead you to revenue, and that's how you refute these types of litigations. And then you can have a chance potentially to fight.
Mm-hmm. So that's a good question in my head right now. Is at what point does a doctor say, "Hey, listen, I think most doctors, if they're just one-on-one, it's just them and some staff. One, they don't have enough money to hire an attorney, right?
Right.
And two, they're probably very hands-on.
Right.
At what point do you suggest, like, hey, whether it's a revenue amount that they're making, whether it's a number of offices that they have, or a number of associate doctors that they have, at what point should they say, look, this is a business now, it's a big business, I need to get an attorney? Like, what do you advise people?
Well, I'll tell you this. My office, Jeff Cohen and I, we run the Florida Healthcare Law Firm, and I'll tell you that what we've done to combat that issue is we have come up with constructive pricing. When a client comes in with very dedicated questions that don't really require us to draft anything or prepare anything, and they need just guidance, and they need to feel like they just don't understand what they're reading in the law.
Okay.
We do flat fee arrangements in those scenarios, and what that does is that includes essentially them meeting with us, asking us their questions. We answer them on the phone. We recap them in writing, and we give them a legal roadmap.
Okay.
And the client gets to take that with them for an affordable price.
Okay.
So even us, our rates are, I would say, competitive in the market, but I would say people that are in our same caliber of experience, it's very expensive. I mean, I'm seeing my buddies over at McDermott Will, Nelson Mullins, they're charging, $1,500, $1,700 an hour. We are way below that.
Yeah.
And we believe that for us, it's our duty to do that, to help, Florida medical providers to stay in business, because unfortunately legislation is pushing them out. Yeah. So I would say that we're an affordable option. I have colleagues that, let's say I had a conflict and I couldn't represent you for whatever reason, I have colleagues that are also competitive in pricing and they could help you.
Okay.
But it's don't just ask the question, how much is this going to really cost me? And call us, because we're very transparent with our pricing, and we'll be honest with you.
Yeah. And another thing is, if you're doing pain management, okay, whether you're a chiro and you're doing pain management once a week in your office, or you have a chiro and pain or ortho, need an attorney. We have a mutual friend contact that we know, and he's like, he's trying to ask me questions. Smart guy, nice guy, trying to ask me questions, and I'm like, that's kind of outside of my scope. And connected him with you, and now he's compliant, but he wasn't compliant before. And I see it all the time. Pain management doctors, you guys are making plenty of money, okay? Hire an attorney. These guys, I don't know what it is, pain management, ortho, they're just like, I'm a doctor, I don't need an attorney. And the amount of laws that are involved, like you've told me some laws, I go, what, that's a law?
Yep.
Needs to be addressed early on too, so that they can continue to grow and do things the right way.
Right.
So I highly suggest, if anybody, especially doing personal injury, right now Allstate is hot. They're going after a lot of pain management clinics. If you do pain management in Florida, expect a letter from Allstate if you bill personal injury.
Right. Right.
Yeah. Yeah. So anything else you want to go over? Is there anything on there that we didn't cover?
I think we covered everything on the list.
Okay, cool. Well, thank you so much for being here. Appreciate your time, your knowledge. If anybody needs a healthcare attorney, Carlos is here. He's awesome. He's incredible. I fully support him. I've recommended him tons of times. I know he does good work. So please contact him. Whatever your healthcare issues are, he can help you if it's related to this LMT thing or not. And so thank you so much for being on the show, man. Appreciate you, dude.
Abe, thanks for having me again, man.
Thanks,
Always a pleasure.
Thanks.